We now know the Crown Prosecution Service designated Lucy Connolly's case as an emergency, fast-tracking it for rapid approval by the Attorney General on a Friday night. An emergency? For a tweet that was deleted within 3 hours? If that doesn't set alarm bells ringing, it should. What this fast-tracking reveals is how justice is being applied, and we ask whether the system is acting impartially or politically. Through a subject access request, it has now emerged that the CPS formally marked Lucy Connolly's case as an emergency. That designation required urgent sign-off from the Attorney General, Lord Hermer, and that sign-off happened rapidly on a Friday night. This is not routine procedure. Emergency classifications are meant for situations demanding immediate action. Typically, they involve imminent threats, serious national security risks, or urgent public protection concerns. So the question we need to ask, what made this case so urgent? What made the tweet that lasted for 3 hours so urgent to protect public concerns? Lucy Connolly was sentenced to 31 months in prison for what's been described as an intemperate and ill-judged post on X in the aftermath of the tragic Southport murders. The post was deleted within 3 hours. There was no prolonged campaign. There was no sustained incitement over weeks. She didn't have an organised movement behind her. It was just one post removed the same day, after 3 hours. Yet the machinery of the state moved at such an alarming speed, making it an urgent case. Here's where it becomes even more significant. For certain offences, prosecution requires the consent of the Attorney General. That safeguard exists precisely because these cases can involve sensitive questions, including freedom of expression. Despite public claims of distance from the process, the Attorney General's approval was necessary. And according to the newly revealed information, the CPS actively sought and secured that approval under emergency conditions. That is active authorization. Now, compare this to another recent case, that of rapper Chandra. In that case, the CPS failed to secure the Attorney General's consent in time. They were a day late, and as a result of that delay, the case collapsed. So let's compare the two cases. Lucy Connolly's case, emergency, designation, rapid escalation, Friday night sign-off. Chandra's case, missed deadline, procedural failure, prosecution falls apart. Same institution, same requirement for consent, very different levels of urgency. At the very least, this creates the perception of selective intensity. Justice must be consistent. I'm sure you agree with me. When one case involving speech is treated as an emergency requiring extraordinary speed, while another fails because paperwork wasn't processed in time, public confidence inevitably suffers. The issue isn't whether you agree with what Lucy Connolly said. I didn't agree with her. The issue is whether the system is applying its power evenly. Emergency designations are serious. They signal exceptional circumstances. If controversial speech can be escalated to that level of urgency, we need clarity on the criteria and transparency about why. Because without that, the impression of a two-tier approach becomes hard to shake. This isn't about defending bad judgment online. It's about defending equal judicial process. When the state moves faster in some cases than others, and when emergency power appears selectively applied, the question isn't just about one defendant. It's about the integrity of the system itself. As always, let me know your thoughts below in the comments and tell me, was this appropriate urgency or was it a case of an example being made? And if you value this channel's scrutiny of the police and the judiciary system, please subscribe and help the channel get stronger. Thanks for watching.